I think the first tip that I would give any solicitor is to go prepared. So it is not the case that if you've represented adults in very serious cases that you are going to be equipped to go to the youth court. You need to know what the law is, and you need to know the procedure so that you're confident to advise the child that you're representing.
Practical steps that I take to ensure I'm prepared are things like trying to get as much background information about the client before going to court. So if they're a client that's known to your firm, then ensuring that you have sort of historical pre-sentence reports, historical records that they might be regarding their like psychological assessments, things like that. Because young people really don't like repeating themselves. So if they're a young person that's known to your firm, it's really good to have that knowledge beforehand, and also you'll know how to approach the client from the outset.
You must know the law that you are practising. Youth justice is incredibly specialist, but because it's incredibly specialist, it's exciting, it's innovative, it makes a change, and it's everything that I wanted to be a lawyer for. So I would hope that those practising in the field could really understand and try to implement that when they are dealing with young people and children.
Understand the importance of communication. If you don't engage and gain the rapport with the child that you're representing, then you're not going to represent them properly. Children, by their very nature, will have coping mechanisms, particularly if they have communication needs. The fact that they're compliant, the fact they nod their head, they appear to be following what you're saying, the fact they may be street smart, so they've got language that suggests that they understand the court process and what's happening, does not actually mean that they fully comprehend what you're saying to them, but perhaps much more importantly, the impact of what will happen in court for the consequences on them in later life. An example is children can sit in the dock during a criminal trial. They can be convicted, and when they go down to the cells, not understand that being sentenced to a custodial sentence means they're not going to go home with their family. The consequences we may draw as adults are not natural consequences that children would draw, so everything will need to be explained to them in simple and understandable language at their level. And you can't just say, "Did you understand?" You need to get them to explain back to you to really know that they have understood what you've advised them.
Really need to think about the way you're presenting to the client, because clients can pick up on you being flustered or nervous. You also need to be prepared to give a bit of time to young people, and they're not going to know exactly what you mean. They're not going to have necessarily decided, like some adults have done, what they're going to plead before they get to court. And it's really important, your approach is really important. It can go very wrong from the first hello.
I think that you must understand the person that you're representing, the young person. They have such extensive needs. They may not communicate effectively with you, but it's your job to communicate effectively with them and to be able to perform the best role that you can. So communication is of massive importance.